Full house.
Call to order, please stand for the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, everyone. Welcome to the November 2nd, 2017 Hillsborough Township Planning Board meeting. This meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, Sunshine Law. Roll call, please.
Mr. Peason?
Here.
Mr. Wagner?
Here.
Mr. Hestag?
Here.
Ms. Pecoraro?
Here.
Mr. Scobo?
Here.
Vice Chairman Julian?
Here.
Committeeman Delcour?
Here.
Mayor Sarachi?
Here.
Chairman Mr. Lapani?
Here. Next order, deposition minutes. There are none to review. We will next go to resolutions. First is the Distinctive Properties LLC, file 09 PB06 SRV, which is a 2017 extension, which is free refreshment in your
Mr.
packet.
Chairman, all members of the board present may vote on this except for Ms. Pecorino.
Thank you. Entertain a motion to approve the extension.
I'll approve it.
Thank you. Second?
Second.
Okay, roll call.
Mr. Peason?
Yes.
Mr. Wagner?
Yes.
Mr. Hestag?
Yes.
Mr. Scobo?
Yes.
Vice Chairman Julian?
Yes.
Committeeman Delcour?
Yes.
Mayor Sarachi?
Yes.
Chairman Lapani?
Yes. Next would be Raymond Drake, file 17 PB03 SV, which is again also in your packet.
Eligible members, Mr. Chairman, are the Vice Chairman, Mr. Peason, Mr. Hestag, Ms. Pecorino, Mr. Scobo.
Okay, we'll entertain a motion for those members of eligible.
I'll make the motion.
Thank you. Second?
I'll second it.
Thank you. Roll call.
Mr. Peason?
Yes.
Mr. Hestag?
Yes.
Ms. Pecoraro?
Yes.
Mr. Scobo?
Yes.
Vice Chairman Julian?
Yes.
Thank you.
Thank you.
All right, so at this point, next order would be any planning board business. There seems to be none, so then we'll go right down to any business from the floor that is not on tonight's agenda from the public. Okay, seeing none. There are no considerations of ordinances, so we will go to the first public hearing, which is Hillsborough Estates Homeowner Association Incorporated, file 17 PB09 MS, block 199, lot 19.07, 19.09, 1910, 1911, 12, 13, and 14, Northview Drive. Applicant seeking amended final major subdivision application to correct and clarify recorded easements filed from original preliminary and final major subdivision application 05 PB13 MJP. Resolution dated 2/7/8 and 08 PB11 MJF. Resolution dated 11/6/8 on the property in the CR Central Residential Zoning District, EC review of 10/23/17. Counselor.
Thank you, Mr. Chairman. My name's Henry Chow, the law firm of Hill Wallach, here on behalf of the applicant, Hillsborough Estates Homeowners Association. I believe we are in conformance with your public notice requirements. We've submitted an affidavit of proof of service and publication to the planning board secretary, and I didn't hear of any problems related to that.
No issues, Mr. Chairman.
Thank you.
Okay, so we're before this board at the township's request to correct an error that was in the conservation and drainage easement that was prepared and recorded by the builder back in 2010. And since the conservation and drainage easement was prepared and recorded as a condition of the 2008 final major subdivision approval, we need to come back before this board and ask for an amended subdivision approval in order to correct that easement. The builder is no longer around, so it's on the small group of 17 homeowners, some of whom are here behind me, to pay for this and to get it fixed. Essentially, we have a meets and bounds description that's attached to the recorded easements that is incorrect, and that it doesn't match the easement limit shown on the final recorded plat. That's the first issue. The second issue is that the easement fails to make a distinction between the conservation and the drainage areas. And the boundaries are actually different and need to be delineated so that routine maintenance can occur in the drainage easement area to keep the drainage swale clear and free and to keep the drainage inlets free and clear. So no new work is being proposed at the site in connection with this application. We are essentially just correcting the legal paperwork. The only visible change is that the non-disturbance signs, which are currently, as close as 5 feet away from some of these homes, will be pushed back to where the actual conservation easement boundary is. And it's important for the association, and I believe also for the township, to get this corrected, because the association's inability to conduct maintenance in the drainage area has an adverse impact on the site to properly discharge stormwater. So that's why we're here before you. We do have the review memos from your planning director, environmental commission, and township engineer, and we're prepared to discuss the questions in those review memos. As far as I can tell, there's really just one issue that we may have to discuss, which is the request for a landscaping plan in the conservation area. I believe that originated from the township's health official some years ago. We're not sure where he got that idea from. He may not have had a good understanding of what a conservation easement is, what the purpose of it is. By definition, we're not supposed to do anything in there. It's supposed to grow wild. And for practical purposes, that may not happen because the conservation easement largely overlaps with a Buckeye pipeline drainage easement. And we definitely aren't supposed to do anything in that easement. It's up to them to do whatever they need to clear the vegetation to repair and maintain the pipes. So that's kind of where we're at. I think that's really the only issue that we may have to discuss. Other than that, we do have 2 witnesses tonight. We have Lee Metters, who is the president of the Homeowners Association, who's prepared to give some background on how this problem occurred and how we ended up before this board, and to kind of show you some examples of what the problems are. And we also have Michael Ford, our civil site engineer, to discuss the any technical issues associated with these easements.
All right,
So,
whatever one you'd like to call first. It's
sure,
up to you.
we'd like to call Ms. Meters. I don't know if you
Sure.
want to swear them all in
You come up
together. or-
and-
It's up to you, counsel.
Oh, okay, sure, I guess.
You want both sworn in
Sure.
at this point?
Mr. Ford, you want to both be sworn at the same time?
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes, I do. State your full name, spelling your last name. Come on up to the mic, please, ma'am. Sure. Thank you.
Lee M. Metters, Leigh, M as in Mary, last name M as in Mary, E-A, D as in David, E-R, S as in Sam.
And your address, please.
29 North View Drive, 3 words, Hillsborough, New Jersey.
Thank you.
You're welcome.
Michael Ford, F-O-R-D, with Van Cleef Engineering, 32 Brower Lane, Hillsborough, New Jersey.
Thank you, Mr. Ford. We'll see you later. Please have a seat, miss.
I think we're going to have an exhibit to go with Ms. Metter's testimony.
Or just we give it to the counselor first and to our, so they can record that?
Unfortunately, they're black and white.
You want to have A1?
So marked. Welcome. Thank you.
Do you want to describe what that exhibit is while he's passing it out,
Sure,
please?
it's just a series of pictures that Ms. Metters put together showing the area in question where the drainage easement and the conservation easement areas are, how they back up to some of the houses, some of the signs that are really close to the homes.
Are these pictures taken by you, Ms. Wetters?
Yes, they are,
Thank you.
except one that's from Google Earth, which I've downloaded and just give it oversight.
Just hold the microphone close, please.
I'm sorry.
Yeah. Be a rock star, right up close.
Yeah, the pictures were taken by me, except for the last one in the exhibit, which is a image from Google Earth.
Okay.
Taken down this week, just to give you an overview.
And these pictures were taken recently?
Some of them were taken recently, some of them were taken probably about 2 years ago.
2 years ago, okay.
The conditions remain the same.
Okay.
Okay, Ms. Metters, can you just give some background on how we ended up here before this board and walk the board through some of the problems experienced by the association and homeowners as a result of the mix-up with the conservation and drainage easements?
Sure, and good evening, everybody, and thank you very much for your time. Well, I'll try to be brief and make it easy to understand as best we can. The background of this is that probably about 2 years ago or so, once we had received a notice from the town via the builder indicating that there was some concern that we were mowing not the conservation easement, but the drainage easement, keeping it so it would work properly. The note had told us if we did not decease, that there would be construction fences put up, sort of like orange construction or brown construction-related items. At that point, we got concerned. Again, we were not in control of the homeowners association, but we did meet with the town. They were receptive to us to try to understand the problem and figure out the best way to solve this. Long story short, in meeting with the town, we highlighted to them several concerns. One being that the drainage easement and the signs associated with the drainage easement were very close to a number of the houses. Basically, for some of the neighbors, if they opened up their back door and stepped out, there was an easement sign sitting right there, not 2 or 3 feet away. If you go to any exhibit that we provided to you, page 4, you'll see an example exactly of a sign that's been, put up, and the exact distance it is from the rear of a home, about 6.5 feet. So with the limitation that the town was, sort of looking to enforce, our concern was that with the grass being able to grow in the drainage easement, that we would have concerns about overgrown grass, there are deer in the area, ticks, fleas, things that really wouldn't make it hospitable. Our neighborhood is filled with a lot of children. They play. They go in backyards. We basically were looking and we're concerned about the safety, of our children. We also were concerned about the drainage easement operating properly. Doing some homework, we came to understand that it needs to be sort of kept at a low level in order to make sure that the water from the swales that are built into the property properly flowed, and that none of the piping and so forth would get backed up. In other words, we were wanting to make sure that the easement and the drainage easement operated the way that it was supposed to operate. With regard to the conservation easement, it's an interesting thing. We don't have the history on it, but it's sort of not I'm not going to say it's not standard, but there isn't anything in particular that's being conserved, except some poison ivy and also some barbecue grills and bricks and some other things there. So after meeting with the town, it was determined that the best way to deal with this was to make an application. And so we hired an attorney and started to do some more homework. We hired an engineer to figure out how best to solve this particular problem here. So.
Did you want to direct the board's attention to any of these pictures in particular?
Yeah, I think a couple things which I find when you look at a blank piece of paper or if you just look at a scheme, you don't get a sense of what the area looks like and what's going on there in that. So if you look at on page 2, what you're looking at there, and sorry, I have a colorful set, but it doesn't matter, you can see it well. You're looking at the drainage easement. You're looking at the rear of a neighbor's home, and basically, the way the drainage easement runs. Underneath the drainage easement, there is piping. There are also drains, in various different, locations. But that's the way it looks. If you look to the left, you'll start to see some pine trees. That's the beginning of the conservation easement, and sort of the line there. Those trees were put in by the builder. In fact, additional trees were put in probably about a year ago to finish off the plan, the bonded, I guess, I'm not going to say bonded plan, but the...
Right. I think what happened was the builder split and the township called in the bond to get a landscaping plan done and to get the vegetation installed. That's my understanding.
So if you go to page 3, and I'll walk you through, it's just a very short presentation there, you'll get a sense of, with regard to the drainage easement, the waters, when they do come, flow into a detention basin. The detention basin, if you look on page 3 towards the rear, there's like a little cement item there. The water collects there and then flows out the back to, and works, I think, as it's supposed to work. So, slide 4 we already hit on, which again, you can see these are the signs that are scattered in the development and, the closeness they are to the houses. And then in slide 5, what I took a picture of there to show you is that you're seeing the rear of one of the homes. It's actually the rear of my home. And it's all the way to the rear, so it's actually, in the conservation easement. It's mowed, not by us, and you'll see the Buckeye, one of the Buckeye pipeline designations. So there's a pipeline there. It is cleaned out by, either the, Buckeye Pipeline Company or some other party, but not us, but you can see how that's sort of set up. And that is, or runs concurrent with the conservation easement. So it is, I guess, upkept by the Buckeye Pipeline Company. Finally, in chart 6, which will give some, I think, amplification to what you'll see on Mr. Ford's charts, is the latest Google Earth shot of the neighborhood. And you'll get a sense, if you look, you'll see each of the houses, and this is not every single house, but the houses that have numbers belong to the Hillsborough State Homeowners Association. And you'll see the easement and see how it runs. So again, if you look sort of in the middle, and I know it's not as colorful, you'll see a number of pine trees and so forth. That is, what was planted by the builder in accordance with the bond that was called in, not the builder, but the town. And you'll see the drainage easement. It's a little brown in this picture. And then when you see the greenery and sort of filled in, that's the conservation easement. And that's what it looks like today. So you can see it's clearly delineated, but just not in the plans that we have. I'm going to stop there because I want to see if there's any questions or concerns or probably more detailed information that Mr. Ford can give. But Henry, if there's anything else I should fill in, let me know.
No, I think that covers it from our end. Are there any questions from members of the board?
On that last view there, where you're showing the overhead, where would the signs that are sort of...
Some of the signs...
Where would they be? Which houses would they be?
Sure. There is a sign plan that was created by the town as to where the signs are supposed to be installed. They were installed after the homeowners moved in, so the builder didn't have them up at the time of moving in. Sorry. Where the sign, you can't see the signs as clearly here. I guess Google Earth is, and that it's great, but it's missing there. But in some of the houses, to give you an example, house number 25 and number 27. 27 is a house that has a sign that's 6.5 feet from their rear. House number 25, if you open up their back door and step out, it's less than 6.5 feet. There's a sign basically sitting on a slider. Some of the signs have been removed, not by the homeowner. Some of them Mother Nature just took out. Some of them other people have moved, or they've been flipped around, not by us, by, I don't know who. So there is, again, a plan that was put together. The signs are, I think, almost all of them are installed. There are some missing, but not to any action of anybody in the Hillsborough Estates Homeowners Association. I don't know if that answers your question.
Now, is that sign marking the beginning of that easement, Mr. White, or is that just saying that there's an easement there?
That is the line of the easement.
The outermost line of the easement?
We had to come up with a methodology to delineate the easement so the homeowners would know, and we would know for enforcement purposes. So the township came up with that sign, and it was always put on the line.
So that's on the line, okay.
Right, and I believe the signs currently say conservation easement on them, but they extend out to the end of the drainage easement. So it's not accurate, not in accordance with the plat that was filed.
Well, actually, it is in accordance with the plat because ordinance 2005-31 created a 75-foot buffer zone for the Buckeye Pipeline in response to the incident that happened in Edison years ago.
Bless you.
And basically, there was no to be any type of construction or grading within 75 feet of the Buckeye's easement in order to protect the residents of Hillsborough. In this case, the applicants sought to have basically a variance, I'd say, I guess, to reduce that and do the grading and the swale and the drainage system put in behind these homes to get some proper drainage because there were some issues with drainage in that area. And the board granted that approval at the time, but it was all encompassed still within
That-
conservation easement, which may have been my mistake.
Right, so that, I think that's the issue, because the sign says conservation easement, but I guess part of it is actually the Buckeye.
I mean, that's why it was set, where, how far it goes out. That's, the limits were established by that 75-foot offset.
And it was established as a conservation easement. There may be drainage easements as part of it.
Right.
That's the conservation easement piece. So the signs are not a mistake.
Okay. Any other questions? All right, so we're going to have a motion to open to public in case there's any questions of this testimony. So we have a motion to open public.
So moved.
Second.
Second. All in favor?
Aye.
Okay. So are there any questions for this witness and her testimony from anyone in the public? Okay, please come up to the microphone, state your name and address, and please spell your last name.
Mike Little, L-I-T-T-L-E.
Can you speak into the microphone? It's
Mike
for recording.
Little, L-I-T-T-L-E.
And use the microphone for your question also. So you can take it out.
Yeah, we'll have to.
There you go. Please proceed.
Okay, L-I-T-T-L-E. I'm at 87 Royce Brook Road, which is 199-104.
Okay?
Okay, so that likely shows on the map as well. So there's, interestingly, there actually has been some misinformation that's being conveyed to the board. First off, that buffer has nothing to do with the pipeline. The pipeline has its own easement. This conservation easement, of course, was determined partly to be valid because there was a need for a buffer to the pipeline so that there be no construction near the pipeline, as per the New Jersey law that was passed after the Edison explosion. So was any board member here present at the time that this development was approved?
I don't believe so, no.
Okay, so potentially I and my neighbor Gary here are the only ones in the room, perhaps, who know the history of this conservation easement.
Actually, sir, Mr. White and I were both here during
Ah.
the application, and our...
You didn't speak up.
And our, well...
Board members.
You asked for
Oh,
board
I'm
members.
sorry.
Contrary to public belief, neither one of us is a board member.
We can't vote on anything.
You're just here all the time.
Yeah, we have nowhere else to go on a Thursday night.
Okay, so you have
Okay, so we
something to
have
share.
some history. All right, so we have the conservation easement, and so I agree with the presentation regarding the inaccuracy of the filing with, I forget whether they're amendments or addenda. There were 3 of those. One indicating the landscape buffer on Hamilton Road and some drainage over there. Another one indicating the drainage for Lot 13. And the first one, actually it's number 1, talks about the conservation easement. And some confusion may have arisen in this because in that document, it specifies both a conservation easement and a drainage easement. And then it goes on to indicate that hereafter referred to as the easement. It's in the filing from the lawyer here. The conservation easement is specified in there as delineated according to the signs that are up, other than the one spot that the applicants have indicated on one of their filings, which is the spot over by, where are we, upside down? Nope, I got it upside down. I believe behind lot 1909. They've indicated that there's that should be drainage and the rest of it's conservation. They've indicated that in their application. So if you follow the surveyor's mark, which I presume that Mr. Chow likely did, that everything's delineated in those amendments by the builder to indicate that what the conservation easement was versus the drainage easement. And that's the only section that was, appears to have been recorded into the final plat as a conservation easement instead of drainage easement. The rest of it actually is a conservation easement as defined in that Amendment 1 that the builder provided and indicated it was a requirement that the buffer be at least 75 feet from the pipeline easement. Okay? So, gotta get my notes. So contrary to the statements that were given, those signs have been moved by the homeowners. I have personally seen one.
Now we've crossed the line between fact and testimony.
Oh, okay.
So I'm going to
All right.
suggest.
I will suggest.
No, Mr.
that-
Let me solve the problem.
Okay,
Be sworn in by Ms. Brzezinski, and at that point, you can testify, and counsel has the opportunity to examine you accordingly.
okay.
Counsel for the homeowners association, not the witness. Yeah.
Raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay.
Okay.
Proceed.
So I will testify that I actually saw the homeowner behind my house move that sign. Okay? And I know that a homeowner a couple doors up has built the fence on the easement line and moved that sign to the outside of his fence. The sign previously was on the inside of his fence. He moved it to the outside of his fence. And Buckeye Pipeline does not come around and mow anything. And all the mowing back there is being done by the homeowners. And in fact, so the disturbance, when they talk about long grass and poison ivy, a lot of the long grass and poison ivy actually shows up from the builder, because the builder went and started disturbing the conservation area that he was not supposed to enter. So I believe that the township knows this, because I thought that the township had fined the builder for this behavior. The builder never, well, I don't know about never. At the time the builder was constructing the swale, there was no registered plan that could be found in the planning office indicating that the swale was going to be built in that location under the circumstances that it was built. And there were some trees and things lost because of their digging down the swale from the original lay of the land. Now, the original lay of the land actually had a what's called a seasonal stream back there. And so the conservation easement was taking that seasonal stream into account. But as you indicated, primarily it's also potentially buffer on the pipeline. So the requirement of the builder indicated that he was not going to disturb anything in the conservation area, and then turned around and did so. And that the builder filed that he was going to have the conservation buffer. I don't know how the builder represented himself to the homeowners when they purchased their property, when it was clear on the plats that were filed with the township that some of these boundaries actually come quite close to where the houses are, as indicated by, I think, the testimony where they indicated it's like 6.5 feet from the houses, not 2 or 3 or 5. So let's see. Looking over my notes from testimony, the issue about the health department and potential landscaping there was not given public notice, so I don't believe that would be appropriate to be discussed at this time. Let's see. There was discussion about perils of a wild area, which of course is what a conservation easement is. So I'm not quite sure why we should be worried about ticks and poison ivy when the conservation easement, if the homeowners would leave it alone, would actually grow up and probably become woods. But it is in the state it is in the pictures that you see because the homeowners keep disturbing it. We are several years behind in having that grow out from what the builder did because the homeowners continue to disturb it in that regard. Let's see. So the conservation easement does not start at the pine trees. The conservation easement actually starts at the signs. That's where it's defined. Even though it doesn't look like it because a fair amount of that area is being mowed. Essentially, the swale is being mowed. So one remark that I want to make is that if things grew in the swale, it is not going to disturb anything because As we know that when this was first put forward, DEP wanted them to actually not put in a curb because of the requirements to try to slow down the flow of water and to have it cleaner by going through the grass. But that was overridden by the committee here, and the builder was allowed to have curbs and gutters. So in terms of the swale, if grass grew long, it just makes for cleaner drain water. If trees grew there, it would make for less drain water going down into the streams. Maybe the bridges would be closed less often in that case. We know that it's a structure that is fairly well engineered. It has a hard permeable surface, then it has a layer of stone, and then it also has a pipe underneath of that. So the fact that it would potentially stop draining water, considering its size, shape, and engineering, I find not a valid argument. The only argument that I think ought to be brought up to this committee is the error in the final plat. The aspect of turning the drainage area, which is part of the conservation easement, into something different than the conservation easement, I don't think ought to be considered in this forum. I think it should remain a conservation easement and that it eventually be left alone so that it can turn to what it's supposed to be. Are there any questions?
Well, I guess we'll let,
So is it your contention that there's no difference whatsoever between the conservation area and the drainage area? That's what you're arguing?
I'm not arguing that there's no difference between a conservation area and a drainage area.
So in your experience, is it appropriate to have woods growing in a drainage swale?
It can.
Okay, can you give some examples of that?
No. Not in this area. In Virginia, there's some. It's a different state.
I'd like to ask Ms. Metters to respond to some of the factual contentions that he's made.
sure. Take your microphone, please, Ms. Metters. It's just for the recording, not just for us.
No, I get it, I'm, make her life easier, much easier. I'm sorry, Ms. Krasinski. I guess a couple of things, going through there, and I'll try to take the last pieces first, if I can do that. Or I may jump around a little bit. Some of them are just not accurate. One, with regard to the conservation easement, and I'm talking about the piece I'm not talking about the drainage swale that runs across the back. I'm talking about the part that's wooded and it's got, other lovely things in there. The homeowner, there's a couple of things with that. Mr. Little makes it sound like the homeowners are running rampant in there and just cleaning things out and doing other odds and ends to that, and that's just not an accurate representation of what's occurred over the last 5 years with regard to, the easement itself. He is correct that the drainage swale part has been mowed. I don't know Mr. Little's background, but I know we've talked to engineers, and there's actually a note from RBZ that indicates that the drainage swale, having things grow in there, and Mr. Ford will probably get to it more because that's our engineer, isn't helpful with regard to that. The mowing, I can't testify to whether the Buckeye pipeline has been there or not. If Mr. Little has been there every day and stared as to whether or not they've been there, I don't know either. But I can tell you that this area behind my property hasn't been mowed by me. It's been mowed by the neighbor that lives there, and it's been cleared out. So I say it not so much as an indictment of that neighbor, but more of the fact that, there are people doing things, with regard to that. As to the location of the signs, again, I don't know of any neighbor who's moved the sign. I know a sign that has been taken down. I know there's a sign that was facing opposite of us, that one morning we woke up and it was flipped around, and there was no reason for anybody in the Hillsborough Estates Homeowners Association to turn that around. So to sort of say everything that's been happening in there has been because we have done it, I think that's incorrect. As to the, I'm trying to think the other piece of the puzzle here. I'm not in a position to refute every piece of Mr. Little's testimony. I don't know his background, so I don't know how much weight we, give to that. But it's up to the board to decide, with regard to that. If there's other pieces, Henry, because I'm just, trying to take some notes that we should go through. I don't know if I can say some of the pieces just weren't quite accurate. And I know my testimony, I just don't feel like having my testimony impugned in that way. I gave an accurate description of what is going on there, in our neighborhood and in our home, and what we're seeking and why, with regard to that. And yeah, ticks and fleas and other lovely things, aren't good, to have. And poison ivy and other stuff that's growing in there is accurate. And I'm going to stop there, because that's not this is not, I don't know if that was helpful for the board in terms of trying to go back and forth and impugning each other. That's not helpful. So.
And we'll have our civil site engineer come up and give the basis for each easement and to discuss the delineations. So
Okay.
we can get into those technical details.
Right. And there are minutes, obviously, from the meetings that would have made the final determinations of what's been set forth, why it's been set forth. And so there is a record that, speaks to that, area. So whether there's a stream there or not, whatever, we'll let the town engineer can speak to that, or our person could, but,
Okay. Anything else, Mr. Little?
I think the only thing I want to add is this aspect of changing the conservation area to a drainage area. It seems to be one of the cruxes of the homeowners association. So while it was clearly designated a conservation area, a swale was built in that conservation area. So then the question probably boils down to, should people be maintaining and landscaping a swale that's in a conservation area, or should it be left alone? And how much stuff might even grow when it's pretty much rocks? The applicant is attempting to arbitrarily define 20 feet from the center line of the swale to the conservation easement is their suggestion of what will remain of the conservation easement after, if this gets approved. So that is a pretty large deviation from the original intent and from all of the homeowners and landowners that were here several years ago asking the builder about the conservation easement and being assured that the conservation easement was going to be there, was going to be of the size that it was defined on the plat, and that it wasn't going to be disturbed. The last part is what a lot of this contention seems to be driven from. So I don't know where the 20 feet from the center line comes from. Should it be 2 feet from the center line, 5 feet from the center line, 50 feet from the center line? That's hard to say. But what was indicated in the Amendment 1 by the builder, the township required the builder for final approval to establish a 75-foot conservation buffer from the pipeline easement. Thank you.
Thank you. Anyone else with any questions on this testimony? Mr. White, would you like to add anything to what was discussed there about that?
Well, there was, the developer did do a little additional clearing, shall we say, and he was required to put back extra trees in the conservation easement, which is probably those evergreens you're seeing in the one aerial photo.
Bill, I'm sorry, I was having a little trouble hearing you. Could you.
That's right. Well, Mr. O'Connor, I think you were here for the hearing for this final plat. I think you are one of the board members. You're the lone board member. Basically, the developer got a little over anxious when he was clearing in the area for the drainage easement to put the pipes in the ground, and took down a few extra trees, from what I recall. Mr. Bellinger took care of that, and there was compensation for additional trees planted back in the conservation, but not in the Buckeye pipeline, because we don't want to plant trees in the Buckeye pipeline because they have to maintain it to get to their facilities.
Okay. Now, is it common for the pipeline to keep an area mowed and free of debris?
I couldn't speak for the pipeline. I know the electric companies do it. I haven't seen a notification, I'm not familiar with if the Buckeye does that as an annual maintenance. Typically, utility companies, the electric company is required to do that.
Right, they usually
You
want
get the notification, they're spraying, they're mowing, they're taking down trees.
Okay. Go ahead.
I mean, we received the notice from the Buckeye Pipeline indicating that they come along and,
Vegetation maintenance.
yeah, maintenance, it's,
Typically
yeah, a maintenance notice has come out, with that. That came out either early this year or late last year. I can't recall the exact date.
I'm just going to share my own. I have the nursery on Hamilton Road, and we have the pipeline go right behind us. And we've had instances where we've encroached on the pipeline and planted trees, and the Eye in the Sky has come, and they have showed up to ask us gracefully to remove those trees from the pipeline. So they are not necessarily looking for a mowed area, but they are looking for a cleared area on the pipeline, from my own experience with the same pipeline. Anybody have questions to add to that? All right. So, do you want to bring up Mr. Ford?
Sure. We could have Mr. Ford. Sure, yeah.
Okay.
Sorry, do we want to...
Can you hear me?
I'm sorry, can I just get you qualified real quick?
Oh,
Can you
sure.
Can you just describe your educational and professional background?
We're good.
Good, okay.
Mr. Ford appears here so much, there's potential he's going to become an alternate board member.
We're going to put a plaque up.
I'm still licensed, employed with Van Cleef Engineering,
Very good.
professional engineer and planner. Okay. Thank you. Thank you for not making me state dates on the record. RU 85.
There you go.
Football wasn't so good then either.
Some things stay the same.
Okay, I'm going to mark A2 is plan sheet number 1 that was submitted as part of the application, which has been highlighted and with color, and I'll describe those highlights in a minute. A3 is sheet 2 that was submitted as part of the application, again with highlights and color to highlight some areas that I'll describe in a minute. And A4 is a soil erosion and sediment control and landscape plan for Hillsborough Estates, which I received from the engineering department of Hillsborough Township, which I understand is part of the record for the approved plans for the project. Okay. Okay. Maybe I can just walk through the highlights of, first, the boundary we're talking about is being referred to as a conservation easement, a drainage easement. It's both. That's part of the, I think, the issue, is that it's not one area separately delineated as a drainage easement and one area separately delineated as a conservation easement. It's a conservation and drainage easement. So when we talk about changing the conservation easement to allow for some drainage, the conservation and drainage easement exists. I think part of the impractical aspects that has brought us here today is the enforcement part of that from the township's perspective, and that is the staff members and what the homeowners are allowed to do and not do in those areas within the easement. And what makes it particularly impractical to not mow the area, we've referred to it as a swale a number of times already, but the swale actually has drainage pipes in it. There's catch basins behind these homes. There's pipes connecting the inlets. And I'm going to go to Exhibit A2 now, directly behind all these homes, and it goes behind all the homes. There's an inlet with a pipe going to another inlet, with a pipe going to another inlet, which collects runoff from the road through a drainage easement between two of the homes, and this is lots 1911 and 1912 that I'm referring to, and then continues on with a pipe to another inlet and down to the detention basin. So the drainage that features that are in that easement are not just swale areas that transmit overland flow. They're underground features, and obviously we can't allow trees to grow over top of pipes and inlets that are intended to provide for drainage. And these are drainage features that are responsible for the homeowners association to own and maintain. Okay, so that's really, one of the fundamental engineering aspects of this application that is intended to clean up what was intended. Now I'll refer to A4 now. A4, which is part of the original approved subdivision plans, also has some handwritten red landscaping notes on it. And I understand from Tom Bellinger, the assistant township engineer, that this is the exhibit that was actually produced when the builder, as part of his construction, went into areas he wasn't supposed to, and because of bonding or whatever issues, Mazer Consulting was consulted by the Township Engineering Department staff to come up with a landscape plan to put in some supplemental plantings to restore that area that was intended to be within woods. And this exhibit clearly shows not only the drainage features that I just described, the underground pipes, but also clearly shows the regrading area and identifies the limits of the wood line, what was intended to be the limits of the wood line. So there was never an intention on the approved subdivision plans to have a wood line 6 feet from the back of someone's house, which would be the result of putting up a sign 6 feet from someone's foundation saying it's a conservation easement that they can never touch, mow, or maintain. Eventually it would become woods. So this is really, what we're talking about is carrying out, I think, the intended aspects of the approved subdivision, maintaining a wooded area along between, and we're talking about a buffer between houses. The neighbors are a residential use. This is a residential use. Usually when I talk to the board about buffers and supplemental plantings, I'm talking about buffering between two different uses, a commercial use and a residential use. These are two houses that we're talking about the buffer between. But the plantings that are there, that were planted as part of this landscape plan, are still there, and as a condition of any board approval this body may grant, these plantings ensuring that they are there can be inspected by the township staff. And these are all within that area that we're talking about, delineating that aspect between what was intended to be conserved, that is the wood line, the landscaping, and then the drainage feature, which is the underground pipes and the swale. So now I'll go to Exhibit A3. On both A2 and A3, I've outlined in yellow the entire area of this conservation and drainage area easement. we're not talking about changing the total area. The limits of that easement will be unchanged. What we're looking to do is really corrective action to delineate which portion is for drainage, that is, can have some things done to it, like mowing a lawn, keeping trees from going over top of storm drainage pipes, and what areas will be preserved and the trees won't be touched. The trees that were there and the trees that were planted. And that's where the conservation easement area signs would be moved to. So they would be moved from 6 feet off of someone's foundation to 10 feet on the other side of a pipe. When we talk about trying to delineate the limits of the drainage area easement, typically with drainage easements, they're 20 feet wide, 10 feet on either side of the pipeline. That's what we've endeavored to do here, and also follow what was intended to be the proposed wooded area limit. So the blue area on Exhibit A3 would be the drainage area portion of the easement, and that would be a drainage easement that would be filed and recorded. It still has that same limit from the existing overall drainage and conservation easement, which includes that setback of 75 feet from the Buckeye Pipeline easement. So the drainage easement, the blue easement, wouldn't allow someone to build something there. They would still be limited by the easement limitations, just like any other drainage easement, including the drainage easements that exist between two of the homes to carry drainage from the road down to this pipeline, the drainage pipe that leads to the detention basin. The green area would be that remaining portion of the drainage and conservation easement that exists today that would be specifically intended for conservation. That would include that intended wood line, the existing woods, the planted woods, and as the Environmental Commission points out, and this is not something we're looking to change, but it also includes that area which is the Buckeye Pipeline that's at the very rear of both properties, both the subject site and the neighbor's properties. I feel like I'm putting everybody to sleep. I think it's really pretty straightforward.
Your testimony is always riveting, Mr. Ford.
So with regards to the reports from your professionals, Mr. White has asked that we specify what would occur within the easements, and like I've said, we're basically taking the conservation and drainage easement and splitting it into two areas. So it's easy for the township staff to enforce what can occur beyond the conservation signs and woods cannot be touched, and what can occur within that drainage area portion so that the homeowners association can in perpetuity maintain the drainage features, in the swale and the pipes and the inlets that are behind these properties. And I think the other thing that's important to note here too is not only are we really doing this all on paper, this is recorded documents, but there's no physical changes we're proposing. We're not proposing to clear more area than what's cleared today. Factually, if someone were to maybe, look at this letter for letter, the conservation and drainage easement that's there today says you can't do anything in that area. So the homeowners that are now mowing that area behind their properties over top of the drainage pipes are in violation of the easement. But it's a practical area where you can't really enforce what's been put in writing, because not only can't you let trees grow over top of the storm drainage pipelines, I think we can all acknowledge too that you can't have a tree grow within 6 feet of a house to a point where it would eventually disturb the foundation of the house and jeopardize the safety of the people in the house. Okay. So there was Mr. White's memorandum. The applicant should clarify the purpose and limits of each easement. That's actually the intent of exhibits, pages 1 and 2, exhibits A2 S2 and A3 that were provided as part of the application. We've taken that conservation and drainage easement and delineated it into a drainage easement and a conservation easement. And we've actually already identified on that plan where the standard Hillsborough Township Conservation Area signs would be moved to, from 6 feet away from someone's property to about 10 feet on the other side of the pipes that are in the ground. With regards to the 75-foot setback from the pipeline, I think that because we're not changing the overall easement area, the lawyers can include as part of the recorded documents an acknowledgement of this township ordinance that limits what property owners can and cannot do within 75 feet of the pipeline easement. And that is with regards to Mr. White's item 2. And item 3, certainly, yeah, we'll prepare meets and bounds descriptions that would go along with the legal easement documentation that would be filed as a condition of any approval this board may grant. With regards to the October 31st, 2017 memorandum from your Environmental Commission, we did visit the Environmental Commission. We described the subject matter, and one of the outcomes of that discussion, and it's outlined in their memorandum, is that they've actually suggested that why, and the conservation easement is there today, but why extend the conservation easement area over top of the Buckeye Pipeline easement? Because obviously the Buckeye Pipeline easement carries with it allowances for Buckeye Pipeline to maintain the area over their easement to their satisfaction. And I would leave it to the board whether they want to include that recommendation from the Environmental Commission, or perhaps again, the easement document that's recorded could acknowledge the rights of the existing Buckeye Pipeline easement. And we're not, while the area immediately behind the houses, that is the area beyond 5 feet from a property foundation to the area of the swale that's mowed today, we'd like to continue to maintain that area that way, but the owners and the homeowners association is not looking to extend that area any further. They're not, this request is not a request to change anything that's on this document as part of the original subdivision approval and what's on record in the Township Engineering Department with regards to landscaping existing trees to be maintained. And then perhaps with regards to Mr. Maskey's October 12th, 2017 memorandum, and Mr. Chow referenced the discussion matters with regards to a landscape plan. What we would submit to the board is that the need for a landscape plan has actually already been addressed as part of the original subdivision approval and as part of the reaction from your staff appropriately during the construction when the builder went into areas where he shouldn't have, and in discussions with Mr. Bellinger in the Township Engineering Department. He submitted to me an email, and I'll read it. It says, yes, the handwritten landscaping that was prepared by Mazur's landscape expert was made as part of the developer's approval because the developer cut down existing landscaping between the subdivision that they shouldn't have. The handwritten landscaping was added to fill in open areas. So the intention that Mr. Maskey points out is a valid concern, and actually has been addressed by another department and within the township in that implementing the landscape plan. And certainly we can have the township staff review the site conditions to confirm that that landscaping still exists. And that would also include that the conservation area signs be moved to their appropriate location. And I think the conservation easement signs included not only conservation area signs that were on the Hillsborough Estate side, but also at the other side in the area of the adjoining neighbors.
If I may, the reason for putting that comment in about a landscaping, a restoration/maintenance plan is to address the concerns that I've heard today and in previous discussions with the homeowners, that it's basically the conservation area is somewhat degraded at this time. It's overgrown, the mosquitoes, ticks, et cetera. There's been testimony tonight that the builder removed things he wasn't supposed to remove, and perhaps there is a hand-drawn landscape plan on the books now. Whether or not it's been implemented, I don't know myself. My thought is that it would be appropriate at this time to have, and under Mazur's supervision, or at least review, a restoration and maintenance plan for, first of all, removing all dead, dying, diseased trees, all invasives, coming up with a restoration plan for indigenous species that can be allowed to just grow on their own. And once that's done, I guess the homeowners association would be responsible for putting that into place. That's why I put it in. All I've heard is that it's a degraded area, there's problems with it. All right, where's the plan to restore it and for a continued maintenance going forward? In reading through the drainage and the conservation easement documents, there's some words in there about leaving it forever wild. I think we have to be careful with that. This area hasn't been forever wild since the colonial days, all right? Forever wild doesn't mean you just let things go. There are invasives, there's poison ivy. We need to step in sometimes and give nature a hand and help it restore it to what you might consider wild. So I think a restoration and maintenance plan for the buffer area, however it gets described by the board, would be appropriate. I'd also just like to, for the board's benefit at this time, because there's been a lot of reference to the Buckeye pipeline, and I went to the Buckeye website and downloaded this document called Buckeye Partners LP and Affiliates Right-of-Way Use Restrictions and Specification Revision 5. And in that document, they list all the things you can and can't do in a Buckeye pipeline easement. And under 3.2, above ground and underground structures, section 3.2.2A, gardening and landscaping. Trees, shrubs, and bushes are not permitted within the right-of-way. Trees planted outside of the right-of-way should be placed so branches and limbs will not overhang the pipeline right-of-way as the tree matures. Buckeye may trim or remove those trees. B, flower beds, vegetable gardens, and lawns are permitted within the right-of-way. So that's just to give the board a sense of what you can and can't do within the Buckeye pipeline.
Dave, could you read the last sentence again? Sorry.
Yes.
With the lawns.
B is the second part. Flower beds, vegetable gardens, and lawns are permitted within the right-of-way. Buckeye is not responsible for replacing any plantings located within the right-of-way. The first part, A, had to do with trees, shrubs, and bushes are not permitted. Buckeye may trim, remove overhanging branches and limbs that encroach into the right-of-way.
Yeah, I don't think the applicant has any issues with the Buckeye pipeline and then continuing to maintain it. The existing trees and the trees that were planted are actually between the homes of Hillsborough Estates and the Buckeye pipeline. The Buckeye pipeline is at their immediate rear of some of these houses, not all of them. So what Mr. Maskey is suggesting is no problem. I don't think that the applicant, that existing easement, we're not looking to change that at all.
All right, and what about the suggestion about preparing a restoration and maintenance plan?
I think we would defer to, it would be with Mr. White's office. We could review the plan that they had already prepared as part of the original subdivision approval, and I guess actually the enforcement action of what the developer did in there. Make sure that that's been carried out and have them review it.
Mr. Ford, in terms of installing additional landscaping or vegetation in the conservation area, the area of the conservation easement that overlaps with the Buckeye pipeline, what could be put there if trees, shrubs, and bushes are not allowed?
Nothing within the Buckeye pipeline, for sure. There were some trees that were intended on that supplemental landscape plan to fill in areas that were characterized as opened or potentially disturbed by the builder. And those trees, I understand, have been installed.
You're talking about the area between the the homes on Royceville Road and that kind of that vegetation on the other side of the pipeline is what you're talking about there.
Right, yeah, the pipeline easement, and I'm traversing it with my finger now, runs across Northview Drive, basically along the rear of the properties on Royce Brook Road, and then along the rear of the homes. It crosses the track boundary and runs along the rear of the homes on the east side of the Hillsborough Estates project. And then between the Buckeye Pipeline, which presumably would be maintained as Mr. Maskey's described per their requirements.
Right.
There's existing wooded area that was to be left undisturbed. And then beyond that, there was an area that was intended for drainage at the rear of the homes. We're not looking to change any of those physical features and what was part of the original approval. It's really just to clean up the aspect of, and unfortunately, you know, this is actually evident in the project itself where there were areas on the east portion of the tract that had wetlands on them and were in the DNR Canal Commission buffer area that were placed in a conservation easement, just a conservation easement. And then there's a detention basin and some drainage pipes that collect water and go to the detention basin that are just in a drainage easement. There's no other title to the easement. So then the description that's prepared between the applicant's attorney and the township attorney is pretty clear on what can happen in a drainage easement. I think the unintended consequences here really were where the easement was created with a title of drainage and conservation easement. And there's conflicting requirements between those two issues. And that's what we're really clearing up. So then, at the end of the day, the blue drainage easement here will immediately run into the existing drainage easements that's around the detention basin. And then the green conservation easement, that's the portion that we're looking to delineate as part of that existing drainage and conservation easement, will run into the existing conservation easement that's around the wetlands. This conservation drainage easement that we're talking about this evening is not around any critical areas. There's no steep slopes, wetlands that we're looking to protect. It's really just that buffer between residents and that area along the pipeline.
So, I mean,
And that'll be carried out.
in a nutshell, I'm going to try to put it in a nutshell.
This is an easy one.
I know it's not.
No, it isn't. No, it isn't.
I've been
It's,
thinking
it's,
about
it's
this.
complicated.
I mean, in reality, you're going to create this enhanced restoration area, okay? And then however that's delineated between, you know, yourself and Mazer, then you would move the signs, and that would be, for all intents and purposes, your new conservation area, which would be that enhanced restoration area, and then you mow the rest of the area? Is that kind of?
Correct. And that's the way it is today, actually. The area is mowed now. The exhibits that
Except
Mrs. Metters provided
except
with
you
the
don't
photos, that area is mowed today. Yeah, yeah.
you would have to upgrade the landscape plan to whatever, you know, we agree upon in terms of enhancement of the restoration area itself.
Well, it's just, that's the one aspect that is, and frankness, from the homeowners association part of this, they've inherited this issue from the builder. And there is a landscape plan that was already implemented that they understand that was actually prepared to address the issues that you're describing, which are filling in that buffer area, but perhaps the conservation easement that's drawn up between the township attorney, Mr. White's office, and the town attorney can include the aspects that Mr. Maskey's suggesting, which are that It doesn't just say you can't do anything in there, you have to do something to
But that's
continue its,
That's a legal issue at
Right.
that point.
Right.
You know, so if you're asking the board, you know, I would say like at that point, it becomes a legal issue defined by whatever, you know, agreement you come up with at that point. You know, to delineate that, and that'll have to be worked out. Right?
what you can or cannot do. Like, in other words, the conservation easement is eventually filed,
Right.
perhaps would include that you can do certain activities in there, like remove dead or diseased trees or invasive species, because if it's left to itself, it might actually degrade and not continue to provide that buffer between the residents.
All right.
Right, yes.
Mr. Chairman,
Yes, sir.
I've sat quietly for roughly an hour, listening to this. For the record. And the reason I've sat quietly is I keep waiting to hear somebody say something that I haven't heard yet, so I'm going to say it. What the applicant is looking for this board to do is memorialize actions that were taken by the homeowners, not so much the association, but the individual homeowners, regard what happened in their backyards, whether they knew or didn't know, or liked or didn't like the fact that there were conservation easement signs and a conservation easement within a relatively close proximity to their homes. The biggest issue that really occurred was that when this application was approved over a decade ago, there was really no specific delineation as to exactly where the footprint of the homes were going to be. And the builder placed the homes within the approved area in which to do the building, and some of them were exceedingly close to where the easement was established. And what has prompted all of these discussions, which led to this evening, was a homeowner, who I don't even believe is even still a homeowner, finding one happy day that there was a conservation easement sign within a half a dozen feet plus or minus of their home, and couldn't understand why. And the individual who was dealing with this initially, shows you how far back it goes, is the late Robert Ringelheim. And then Mr. Coyce, and to some extent others in the planning department. So what the applicant is really asking you to do is say that what has happened over the last X number of years relative to the easements is now acceptable to be, and that you will therefore memorialize whatever they are and let it go forward. We keep hearing about the difference between the Buckeye pipeline and the drainage easement and the conservation easement. What really is the issue is the conservation easement.
Right.
The signs are not for drainage, they're for conservation. The board wanted that part of those properties to remain in a vegetative state. And for whatever reasons, the builder, the homeowners, et cetera, decided ostensibly once they got out there to do what they wanted to do. So the board and the applicant is here at the recommendation, among other people, of me. Because I sat through multiple meetings with Mr. Coyce and others, with Ms. Meters and the Homeowners Association, trying to find a way to resolve this, and the suggestion continued to come back. You've got to go back to the board to get them to change what was approved. And that's why we're here tonight. But what you're really being asked to do is memorialize the situation that is already out there. Not to basically, I don't know why we need to move conservation easement signs. The conservation easement is exactly where it belongs. The property may not necessarily look like a conservation easement, and that's a decision you're all going to have to make, which is what the applicant is asking. But my understanding, and Mr. White, Mr. Maskey can correct me if I'm wrong, the signs and the easements are exactly where they're supposed to be. The drainage easement is exactly where it's supposed to be. The Buckeye pipeline is not even an issue here, but it's also where it's supposed to be. What the owners want to do is they don't want to replant the backyards of some of these homes in a vegetative state that they find unattractive, unnecessary, obtrusive, potentially health-related. And we've had conversations so that the board is aware. Dr. Belnay was involved in these conversations and others. So a lot of what we have suggested, a lot of what Mr. Maskey has suggested, and Mr. White has suggested, and to some extent I have suggested, is to try to ameliorate a situation that is just there. So I want the board to understand that we can parse this thing up any way you'd like, but ostensibly, everything is where it's supposed to be. It's whether or not you're willing to allow the homeowners to continue to do in their backyards what the developer and/or they were not supposed to do in the first place. So,
Question, and maybe not for you, Eric, maybe Ken, maybe Bill and David. I don't ever recall, though, seeing sort of the combined drainage conservation.
there are in parts. There is a filed copy of both a conservation and a drainage easement, because at points along the way within the property, they ostensibly merge.
Okay, let me, other than this one?
No, this one.
That's what I'm saying. My point is, I don't ever recall seeing that.
No,
right?
and I don't think there's been one in my 18 years here. I just think it simply turned out because of where the drainage was and where we wanted the conservation in parts, they sort of melded into each other, and then were further melded by your 75-foot buffer ordinance back in 2005 related to the pipeline.
So the ordinance, the easement and the 75-foot buffer line for the pipeline, are they at the same point where that sign is, the conservation easement and
The conservation easement signs, I believe, are where the conservation easements were established in accordance with the plans when the development was approved.
when approved?
Within the area back there is a separate pipeline easement.
Right, which is where you couldn't build
Within
closer.
parts of the conservation easement is a drainage easement, which is why there are two filed documents, one which says conservation easement and one which says conservation and drainage easement, because it points there because of the narrowness of the property, as Mr. Ford has delineated in the plans you've seen. There are parts where they ostensibly melt. But my understanding, and I will stand corrected by both the planner and the engineer, the delineated signs that some people find offensive are exactly where they're supposed to be. The drainage easement is exactly where it's supposed to be. The pipeline easement is exactly where it's supposed to be. And for whatever reasons, between a combination of the builder and some homeowners, not the association, I want that to be, the association is here representing all the parties because they're the only ones with standing. But some of their members may not necessarily have followed all the rules of the situation. And the builder exacerbated it in some cases by literally building homes on top of the conservation easement, which really didn't become aware to the township, I believe, until we started getting phone calls from homeowners who said, oh, by the way, I look outside my home, and I believe the picture is, if you have that,
Yeah, page 3.
A1, I think is number 3.
Right.
Guess what's guess what's like right outside my porch door? A conservation sign. And that's where the situation started.
Okay.
I certainly won't disagree with Mr. Bernstein. Well, I wouldn't. I think he's absolutely right, though, that the conservation signs are appropriately placed given the outer boundaries of what is a conservation easement. any conservation easement has to be based on the resource that it is protecting, be it a wetland, a steep slope, a buffer, a drainage facility, et cetera. So what we have here is, although it's called a all-in-one conservation area, we really have a dual-purpose conservation area. Part of it is for drainage and drainage facilities. Part of it is to provide a vegetated buffer. I believe what the applicant is looking for, or maybe they aren't, but I see it as establishing the rules of engagement for those two portions of this conservation easement in order to achieve the, loosely used word, conservation of that particular resource. So in the portion of the conservation easement where we are trying to maintain a workable drainage facility, i.e. the catch basins and the pipe, what are the appropriate rules of engagement and what are the limits of that area? Can it be mowed, can it be not? In the part of the conservation area that is meant to be a vegetated buffer to adjoining properties, what is the limit of that in order to, and what is the appropriate way to plant that area to achieve an adequate buffer? And what can you do in that area? So I think what I've heard so far is in order to maintain the drainage portion of the easement in a workable fashion, you can mow it and maintain it. There are words actually in the drainage easement that was filed that says the association has the right to remove rocks, brush, et cetera, in order to make sure that the drainage facility operates properly. And again, as I said earlier, we should have a restoration and maintenance plan for that area earmarked for a landscaped visual buffer. And if you have those two distinctions made and the rules of engagement precisely written up for what can and can't be done in each of those portions of the conservation easement, then fine. We don't, Mr. Delcor, I mentioned, had we done this elsewhere, and I'm not aware of any dual easement anywhere else either. We don't have a drainage easement sign. All we have are conservation easement signs, and we use it as sort of a catch-all. So, yes, the conservation easement, and from what I've heard from testimony and looking at the plans, they are not looking to alter in any way the outside boundary of the conservation easement. It's a matter of what are the purposes of the conservation easement, outline those areas that achieve those purposes, and define what you can do in those two portions of the easement. That's my understanding of what we're doing here.
So with that, if based upon the way that those definitions would work, if that was outlined from the beginning, would that essentially give us, would that have provided adequate protections for both of those easements? Are they large enough? Would they serve the purpose that they would have been intended, or does it not really meet and we're just trying to fix a problem that is not really going to fix it, it's just going to pretty up a little bit?
I would defer to Bill, Mr. White, on what's the appropriate width, if you will, to properly protect the drainage facility. Is it 5 feet, 10 feet, 15, whatever it might be. The visual buffer, in a sense, is basically what's left over after that, and that's why I'd like to see a restoration and maintenance plan, an area wide enough to provide the visual buffer that was originally required. So, a 5-foot wide vegetated buffer isn't going to do it. But again, that depends to some extent on how much is really needed in terms of clearing or maintaining or mowing the area on top of the catch basins.
Typically, you're looking at a 20 to 25-foot wide easement for drainage purposes so that you can basically go in there with a backhoe, put the outriggers down, the stabilizers, excavate, cast material aside, get down to the pipe, get down to the structure, work on it, and then put it back. So basically, your typical drainage easement is 20 to 25 feet wide.
I'm sorry, and the segregation here would roughly give you how much?
I'm sorry?
Based upon the way it's being viewed, would give you how much?
I think Mr. Ford testified it was 10 feet from what was the limit of disturbance to the pipeline, which would be basically the boundary between the two, the proposed drainage easement and proposed conservation easement line. It would be 10 feet into the drainage easement to the pipeline. So you're looking to provide at least 20 feet around that pipeline. Not the Buckeye, the drainage line.
Which house, just with the plans up there, is the house that has the sign 6 feet from the house, from there? Just to get an idea where the most egregious is.
It's lot 19.12 and 19.11 both have the existing easement in close proximity to the foundation.
Mr. Chairman, I will admit that I don't recall every piece of this application, but I think to some extent what was envisioned was the houses to be placed closer to the street than further back from it, because the board spent, my recollection, a decent amount of time discussing the conservation easement. It was an issue that Mr. Ringelheim had. And I think, though the parties never discussed where the homes would be placed, I think to some extent it was envisioned that they would be closer to the street than they are now. So therefore, these people would have backyards and then the conservation easement, rather than their backyards literally being in the conservation easement.
Can we just move the houses?
Well, I'm looking at even where the houses are now. I mean, if they put the houses up almost to the road, it's still not much of a backyard the way they did that.
Perhaps if I pass out a copy of A4, which is from the Township Engineering Department, shows the original plans. It's already been marked.
As I said, I'm not suggesting for a moment that moving the houses or the like. I'm just saying that when this was all discussed, long before these homeowners got to live in the homes they're currently living in, or the homes who did and no longer are there, the builder was aware that there were going to be situations where the homes could be closer to the easement than others.
I didn't take you out.
How much of a problem is it to leave it as is and take the signs and put them back by the wooded area? Is there a problem there, or?
Well, that's ostensibly, with all intents and purposes, exactly what this application is.
That's what I'm talking about. I mean,
I think if the board were to consider that situation, obviously I'll let applicant's counsel and engineer, wherever he's educated from, indicate a discussion regarding it. I think one of the major concerns that has come up over the years from the township's staff has been that if there is some kind of memorialized change, that's it. That everybody understands what can and cannot be done, where it can and cannot be done, and we won't find any further encroachment to the point where we now see nothing more than finely mowed lawns that look like a golf course rather than a conservation easement. And I think that's why Mr. Maskey suggested, and I think Mr. White concurred, the necessity for a landscaping plan so that it doesn't get any worse back there from the township's point of view than may already now exist.
There's really nothing we could do here tonight, though, in terms of unless we see the plan and the restoration plan. And that's an issue that has to be resolved.
Well, you could make it a condition of the approval, and therefore, in order for this to be ultimately approved, all of that would have to be put into effect,
Right.
preferably before the board voted on the memorializing resolution. That's up to the applicant and council. I'm not going
I
to
think
presume.
what we're presenting is that through our discovery of contacting the engineering department and perhaps everybody didn't have the benefit of what Mr. Bellinger provided, which is A4, identifies that buffering, landscaping improvements. I think what I'd also like to highlight on A4 is that the board members look at A4 in comparison to the exhibits A2 and A3, which are plan sheets 1 and 2, which show the existing homes, the way they were built with regards to, and in comparison to A4, which was the subdivision plans and the plans for the intended locations of the homes. In preparation for the application, what we did is our office didn't prepare the subdivision plans for this project, but what we did is secured plans of survey from all of the owners of the properties in question, as well as the as-built plans from the engineering department that were part of the certificate of occupancy for those homes. So the existing homes are shown accurately on the existing conditions plan and the proposed condition plan, sheets 1 and 2, that were submitted as part of the application. And that what we discovered in contacting your engineering department is A4, which is the soil erosion and landscape plan that has handwritten red line landscaping that was implemented during the construction as at the direction of Mr. White's office to accomplish that buffer that I think everybody is talking about. And we're not looking to disturb that or change that, and any maintenance or ongoing restoration and continued review of that can be part of the easement language for that conservation easement. And I don't recall a condition where we had a conservation and drainage easement written in one document. They're opposing, and in this case, we're not talking about even an overland swale that could potentially be construed to allow some vegetation over it. We're talking about a drainage area that has underground features in it, pipes, catch basins, that obviously cannot have vegetation growing over it.
If I could just offer to the board, the association will agree to satisfying the condition of basically what Mr. Maskey suggested about, having a restoration and maintenance plan for landscaping in the conservation areas that are delineated there. But we want to make sure that it doesn't, get into the areas that we have delineated for draining for the reasons that Mr. Ford has mentioned.
So at the end of the day, we need to put a line on the map, okay? So,
Right.
Mr. Ford, sheet 2, which is the amended easement, which exhibit is that up there?
That's A3.
Which is?
The middle one.
The middle one, okay. My understanding, correct me if I'm wrong, what the applicant is proposing is that the line be redrawn as shown on sheet 2, A3,
Correct.
which shows a varied width easement covering the drainage facility and a varying width on the portion of the conservation easement that's for the landscape buffer. And I think that's what they would be asking. If the board were to make a decision or to vote on something concrete, it would be to delineate these two lines on the map as shown on sheet 2. So you see the exact, and the question was asked before, can we move the signs? Certainly, but we got to know where to move them to.
Yeah, we need a line to move it
So
to.
we need a line on the map. It's as simple as that, really.
Right.
For all this discussion, it's really about a line on the map.
But that goes back to my earlier question, though. If you move the line, does that then create other waiver requirements?
Not to my knowledge.
Shouldn't have. The board already approved them to do the grading, put that drainage system within that 75-foot buffer.
Okay.
So that was pretty much way back then.
I think that, yeah, drawing a line on the map, and then again, it would differentiate. We'd have, there's rules applying to the drainage portion of the easement, and there's rules applying to the conservation/buffer portion of the easement. And those rules are fairly direct, I think, over whatever the appropriate width of the drainage easement, and I would defer to Bill on this. Yes, you can mow it, it needs to be kept clear, and the catch basins have to be left unencumbered, and there has to be an appropriate ability to maintain the pipe. The area that is delineated for conservation/buffer requirements, upon the restoration of the area, no structures or any other plantings can take place in that area. Future maintenance can take place in terms of continued removal of diseased, invasive species, so it does need to be maintained. You can't leave anything wild around here, it just goes wild, and that's not really what you want. So those are the rules, that would be the rules for the area on top of the drainage facility, and those would be the rules for the area that is meant to buffer the properties on Roycebrook Road.
Now, there was some testimony, excuse me, Counselor, that one homeowner put up a fence. Would that be considered something they could put up in that? I don't believe that's so correct.
I would say no structures.
So
No
no
sheds,
fencing, no
no
sheds.
fences, no pools, no swing sets, no all the things that you normally don't find are not allowed on any utility or related easement.
Right. Essentially open space.
Mm-hmm.
Okay.
5.
We need to open any questions to Mr. Ford from the public before Mr. Little?
I remind you, Mr. Little, you're still under oath, so just use that as.
Thank you for the reminder.
Well, for the record, where it's the reminder, but also just in terms of your own comments.
Mike Little, 87 Roycebrook Road. If I recall, the filed Amendment 1 in the folder that was available for public review actually does delineate the difference between conservation and drainage easements in the discussed area. It indicates the 75-foot buffer is to be conservation, and by implication, the 25 feet that are left would be drainage in that respect. Now, I do understand the concerns for maintaining the underground structures. I'll stop calling it a swale. And I think that's certainly a concern that needs to be addressed by the board under this particular situation. One thing that I am concerned about in terms of drawing a line on the map and taking the lines from the map that was provided by the applicant is that the applicant actually is requesting some of the conservation easement area that is not adjacent to the drainage area to become a drainage area. And that specifically would be the small section that abuts Northview Drive.
Can you point to that on the map, please?
A little, Mr. Ford can give you, no, he can't.
This area.
The block.
Mr. Ford could clarify whether there's any underground structures there or not.
Yeah. The highlighted area is adjacent to, what, 1907? Am I right, Bill?
I think it's 07, yeah.
Yes. Yes.
This space.
Yeah, there's no structures there. You're correct. It looks like a swale between that property and the adjoining property. And on A4, which is the landscape plan that was approved as part of the project,
The
there's...
remediated
Correct.
landscape plan?
Correct, right. Those plantings would be preserved by virtue of creating it that way. So that's an area too where if you look at A4, this is the first house on the right-hand side as you come into the project. And I'm looking at the subdivision plans now. It looks like a 20-foot setback from the side property line. And the house shown on that lot with the subdivision plans shows the house about 20 feet off the property line. So if you were to create a conservation easement within that 20-foot area between the house and the tract boundary that couldn't be mowed, maintained, would allow trees and woods to recover, that would be, again, one of those situations where you would have trees growing just too close to what a house is, intended to, to be safe, but we would continue to preserve the easement for drainage. So yes, we're suggesting that that's more appropriate to be identified as a drainage easement, so no structures, all the limitations of a drainage easement, continue the overland swale, but not allow trees to grow there. Not make it woods, and it wasn't woods before.
It certainly was, I mean, it was a buffer for the brick factory. Woods had grown. Obviously, there was not woods there at some point in the past because all of New Jersey has been clear-cut at some point. The only other point, besides clarification of what you can and cannot do on a drainage area, the distance, as I recall, on the publicly available document gave a 40-foot wide drainage buffer, not a 20-foot wide drainage buffer. So that was the scale that I saw and compared on the available document. I think certainly 10 feet sounds like a reasonable amount for maintaining the underground structures.
Yeah, there's areas where the drainage easement would be wider than 20 feet, but that's because of where the location of those physical underground pipes are. And what we're basically taking is that other 10 feet, that is a typical 20 to 25-foot drainage easement, as Mr. White referred to earlier, would have the pipe going down the middle of the easement. In this case, the easement's going to be wider in some cases because there's portion of the easement that's between the pipe and the house that we're going to leave as an easement, and then the other side of the pipe that is towards your property would be that 10 portion of the 20-foot wide pipe. So we're not looking to make the easement wider toward the neighbors in order to preserve and maintain the drainage structures. We're just doing that same typical 10-foot offset of that pipe that would normally be part of a total 20-foot wide drainage easement. Am I making it understandable? Okay.
Yeah, the part
And that would be coincidental, I think, with approximately the intended wood line that's shown on that exhibit that I passed out, that's A4, the reduced color copy. So that wood line would be at about the limit of the drainage easement portion of the existing easement that we're trying, that's the line. The line is the wood line.
I'm not quite sure what the wood line actually is, except relative to where they might have put those trees.
I'm just referring to the subdivision plans that were on record in the engineering department that identify the proposed wood line. And then they also have some supplemental plantings within the wooded area to address gaps in that wood area.
That makes sense.
Yeah.
Okay. The line that seems to be currently established is how close the homeowners felt comfortable mowing to the fir trees that were planted on the remediation. That seems to be the current line. And the distance that I had looked at on the filed exhibit, I only looked at from the center line towards my property, and that appeared to be 20 feet. I do understand that on the other side, actually, if there was any conservation area left over, because as was mentioned, if you just took a 20-foot wide swath and followed the drainage area, some conservation area remains between the house and the drains. But that is, the applicant is requesting that to be treated the same as a drainage area, which in some sense makes sense, because part of it, and whether 20 feet is big enough for the conservation easement purpose of a buffer, I can't comment on that because I don't know what the minimum size might be.
Mr. Ford, can you give Mr. Little your mic for a minute? Mr. Little, can you go on to either A2, A3, or A4 and show us where your property is in respect to this development?
Right here.
Thank
I
you.
have a pipeline easement through my property.
Okay, we're going to take a 5-minute recess. One of our members needs a break,
As does the
as does our stenographer. So we'll come back at 5 minutes at 9:25. Call to order. We're now back in session. It's 9:28, it appears.
Mr. Chairman,
Yes, sir.
if I may, I'm sorry, are you done, or are you going to continue?
You asked me a question and then.
Go ahead, right, go ahead.
I didn't know
Sorry.
if there's a follow-up to that.
So,
I don't remember what.
The question was where I live.
Oh, yes, that was all. Just from a matter of standpoint for
okay,
your reference to the application, that's all.
27 years.
okay. So
Okay.
it comes down to, again, drawing a line, and in conversations with Mr. White, we suggest as a solution that the drainage boundary, the less restrictive of the areas, be drawn 10 feet to the south of the storm drain pipe. And everything south of that towards Royce Brook Road would be in the conservation easement. The one exception would be the tail piece that was spoken of before that actually doesn't have the pipe under it. That would also be considered drainage. So it would be 10 feet to the south of the pipe would be the limit of the drainage easement.
Okay?
Throughout the length.
Through the length of the pipe, yes.
The length of the pipe. And then anything south of that would be considered conservation.
Correct.
To understand that, Counselor? What?
Yes, Mr. Chairman, we're fine with all the conditions that Mr. Maskey has proposed thus far.
Okay.
I just want to make sure we're clear that the 10-foot across the length of the drain, that's...
Correct, correct. And we're going to have meets and bounds descriptions accompanying the easement.
Okay. So then we have a motion.
Oh, we did it.
Oh, wait,
Are there any other
clo-
members of the public?
Any other members of the public? I'm sorry. Oh, we got one more.
Just have some questions.
Come up to the mic first and, okay.
My name is Gary Bowmans, Bowwmans, 83 Roycebrook Road.
Okay.
So this discussion's about moving the line. How will the line be delineated so that everybody knows where it is? The discussion about remediation of adding vegetation or trees, that has to be resolved. That has to be part of this condition. The, what was the other one? Those were the two that really stuck in my head. How would it be delineated?
Yeah, once the line is surveyed, the signs will be placed as surveyed at the boundary,
Okay.
on both sides of the easement, so to make sure they're on
And just to
facing
comment
Northview and Royce
for the
Brook.
future, I mean, this is a debacle that you're all suffering through, and the homeowners are too. I don't understand why when a developer wants to develop property, he has to mark the property, he hires a surveyor, marks the property, has corner markers, then removes them so he could sell the property, so the homeowner has to then pay a surveyor to remark the property. If this was all marked out right from day one, we wouldn't be here. The homeowners making the purchase would know, here's where everything is, you would know where everything is, and this wouldn't happen. I needed to make that comment, because it's just making me not understand how this happens. Because they make the homeowner pay, because they include the cost of that survey in the sale of the house, they remove the markers and hide the detail, so nobody knows what's what, and then the homeowner gets stuck paying twice. My comments.
Thank you. Any other comment or questions?
Mr. Chairman.
I have a question.
Okay.
Are we going to see a plan before approval, or are we going to, how are we going to proceed? What are
Well,
we proposing?
we haven't brought,
I did not telepathically.
Oh, what?
the question is, are we going to see a plan of the changed line?
Proposed changes.
Okay.
Why
Before-
don't we finish this piece and we'll get
Right,
to
right.
that piece?
Right.
Is there any other public?
Any other public comment? All right.
Motion.
Motion to close public.
So moved.
Second.
All in favor?
Aye.
Okay.
I'm on, thank you. As Ms. Bickerina telepathically felt my vibes, we are left with two potential alternatives here, folks. Here is what they are. Potential alternative one is that the board take an action this evening. One of the conditions is that there be a landscaping and maintenance plan, as Mr. Maskey requested, that there be a survey map which clearly delineates where the lines are, and that the memorializing resolution relative to this application is not approved by the board until the township's professionals and the applicant are satisfied as to where the material is. That's option A. Option B, you have a time of decision rule at 12:29. Option B is that if the applicant will not allow option A, is that we reschedule this, continue this application till the last meeting in December, which for us is 12/12. And by that point, we will have a survey map and a maintenance plan approved, which means Mr. Ford and Mr. White and Mr. Maskey have to work during the holidays, and the league, and a few other things. That's a call by the applicant.
I think one would put less pressure on everybody to finish up. Obviously, and I'm going to need to prepare an easement for Mr. Bernstein to review as well, so we're going to need some time to work
I
through
would
that.
also ask the applicant to agree to waive the time of decision on the 29th of December.
And- Correct, okay, if we're going with
A.
alternative A, okay, yes.
And would there be a problem if we extended it till the end of February? That should do it. Yeah, but the point is I want to avoid somebody saying, well, you approved it, but you didn't memorialize the resolution, and since you didn't do it within the necessary time period. So, final decision by the end of February?
That's fine, we grant that MLU extension. Sure.
Christmas. It's a Christmas present. And all other requirements made by the professionals and all other conditions agreed to by the applicant as part of this application.
Correct.
That would be the motion.
Okay.
I'll make that motion.
Basically, put it in the hands of the professionals to work it out.
And if we can't work, well, let's put it this way, by the time it comes back to you as a memorializing resolution, as the board is aware, applicant may not, what we normally do is no resolution gets on the agenda until everybody has approved it. That being the professionals, your office, my office, so by the time it gets to the board, there's no issue about what did the parties agree and not agree to. And I'm assuming, seeing the longing looks from some of the members of the public, probably a plan that they can look at before the resolution is approved.
We will try to get everything on file. We will.
We would ask you, though normally we don't, we would ask that it be done to give them a sufficient time. So some appearance either in February that they're happy with. So,
Sure.
We normally
We'll adhere
meet,
to the normal, 10 days before.
the board normally meets first and second Thursdays in the month, so you're looking at getting it done probably by the end of January in order to make the February meeting.
Okay, maybe we need some additional clarification.
I just, asking if we're going to include the Environmental Commission's recommendation to exclude the Buckeye Pipeline from the conservation easement or include it, that's all.
I don't know.
Yeah, I would,
I think it would be.
Okay.
Yeah.
if there's an issue, you'll let us know.
In the conservation.
Do we have a motion? Do we
I'll
have a
make
mo-
that
Okay,
motion.
so we have a motion.
Mr.
Okay.
Scobo.
Mr. Scobo. We have a second.
I'll second.
Thank you, Bob. And we'll take a roll call.
Mr. Eason?
Yes.
Mr. Wagner?
Yes.
Mr. Hestag?
Yes.
Ms. Becker-Renner?
Yes.
Mr. Scobah?
Yes.
Vice Chairman Julian?
Yes.
Committeeman Delcor,
Yes.
Mayor Sarachi.
Yes.
Chairman Mr. Lopano.
Yes. Thank you all.
Thank you.
We'll see you.
Thank you, Mr. Chairman.
10:30?
There are no correspondence in your packet. Next scheduled meeting will be next Tuesday at the November 9th.
That will be the,
Thursday, I'm sorry.
that will be the return of the veterinary hospital plus the veterinary hospital 2, which is the application regarding the relocation of the temporary parking. So both applications will be on.
Right, I know
And the
Mr.
trailer.
Hashtag said he will not make it, so anyone else that's not going to make it? Bob won't be here.
Is there anybody else who knows they will not be here?
I don't think I'll be here next Thursday.
All right, we're down, that's 3. So obviously, we need
Everybody else.
5 of the remaining 8 to attend.
If anyone else is not going to
and if
make
there
it,
is
please
a-
let
a-
the board know ahead of
Well,
time.
not only that, if there is anybody who missed the first hearing on the main application,
have
if
to-
you're going to need
to
to
review
review the paperwork in order to participate in the second. Because they're coming, the initial, so for the board's edification, the initial part of the application will be for them to come before you to seek approval of the temporary trailer and the temporary parking because their approvals at the zoning board have expired. The zoning has changed, so they're now you're with your jurisdiction, and then we come back to the application that brought them there here in the first place, which is a new veterinary hospital.
We're going to start over.
Well, we're going to continue, but for those of you who may have missed the,
All right. So with that, we'll take a motion to adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.
We're adjourned, 9:38.